What are the key estate planning documents every senior should have in place? Can a trust protect your assets? And when do you need one? How can you or your parents plan ahead for a future long-term care need? I'm Ethan Huizenga, attorney and owner of the Huizenga Law Firm PC, and this is the Siouxland Senior Planning Radio Show. Since I'm a lawyer, we've got to start by getting the fine print out of the way. Since legal advice is extremely personal, you shouldn't take anything said on this program as legal advice. After all, I haven't met you, and I don't know anything about you, your health, your family, your finances, your fears, or, most importantly, your hopes and dreams. Instead, my hope is that what you hear on this program will be educational and thought-provoking. Last week marked the halfway point in our first series, which we're calling Estate Planning Essentials for Seniors. So far, we've talked about wills and financial powers of attorney, and today we're covering medical decision-making using a healthcare power of attorney and living will. A healthcare power of attorney is a document that allows you to appoint someone to make medical decisions on your behalf if you become unable to do so yourself. This person, known as your healthcare agent, will have the authority to make decisions about your medical treatment, including whether to consent to or refuse medical treatments, procedures, and tests. The decision to appoint a healthcare agent is a personal one and should be made after careful consideration. You should choose someone who knows your values, beliefs, and preferences for medical treatment. You should choose someone who is willing and able to make difficult medical decisions on your behalf. And this person should also be willing to advocate for your wishes and communicate effectively with your medical providers. So it's important to have open and honest conversations with your agent to clarify your wishes and expectations for medical care. It's also a good idea to choose an alternate healthcare agent in case your first choice is unavailable or unable to serve. Your alternate healthcare agent should also be someone you trust and someone who is willing to make difficult medical decisions on your behalf. In addition to a medical power of attorney, you might also want to consider creating a living will. A living will is sometimes called an advance directive because it allows you to specify in advance the types of medical treatments and procedures you want or do not want in certain situations, such as if you are in a persistent vegetative state or have a terminal illness. It's important to review and update your medical power of attorney and living will periodically. Your healthcare wishes and preferences may change over time, and it's important to ensure that your documents accurately reflect your current wishes. It's also important to communicate your healthcare wishes with your loved ones and healthcare providers. You might want to provide copies of your medical power of attorney and living will to your healthcare providers as well as to your healthcare agent and alternate healthcare agent. This can help ensure that your wishes are honored and that your loved ones and medical providers are aware of your wishes and expectations for medical care ahead of time. Finally, just like with the financial power of attorney, you should make sure your healthcare power of attorney is durable. Remember that estate planning includes control while you're alive and well, and taking care of yourself if you become incapacitated or disabled. A durable medical power of attorney and living will keep you in charge of your physical care even after you're not able to make those care decisions yourself. For our myth today, I want to differentiate between a living will and a DNR. As we just discussed, a living will is a legal document that outlines an individual's wishes for medical treatment, typically limited to life-sustaining measures like artificial hydration and nutrition and mechanical ventilation. While a DNR order is a medical order that instructs healthcare providers not to perform CPR in the event of cardiac arrest. Both are important components of advanced care planning, and individuals may choose to have one or both in place, depending on their wishes and medical circumstances. Thanks for listening to the Siouxland Senior Planning Radio Show with me, Ethan Huizenga. We'll catch you next week when we wrap up Estate Planning Essentials for Seniors with an introduction to trusts. I always feel like it goes without saying, but please, please, please do not take legal action on your own because you heard it on this program. If you want to dig deeper on something you heard today, the Huizenga Law team would be happy to schedule a one-on-one vision meeting at our office in Orange City, where we can talk about your unique goals for your legacy. Just give us a call at 712-737-3885. You can learn more about elder law and estate planning issues on our website by visiting SiouxlandSeniorPlanning.com. And remember, it's not too late to protect everything you or your loved ones have worked so hard to build.